Welcome to Sumner School Business Immigration Basics. My name is Emily Sumner with Sumner Immigration Law, and in this video, we are comparing a very high-level, quick overview and comparison of the fast-track employment-based green card processes. When I say fast-track, I'm referring to those employment-based green card processes that do not require the labor certification process. We will have a separate series of videos on the labor certification process coming up, so get excited. But these particular classifications do not require that, and therefore are sometimes referenced or referred to as the fast-track employment-based visa classifications or processes. So of these options, we want to compare and contrast, see what's different and the same amongst them. Of these options, which of them can be self-sponsored, meaning a foreign national can file it on their own without having to have an employer sign off on them, without having to have an employer's support, without having to have an employer pay for them. Those options are, self-sponsoring options are the EB-1A for foreign nationals of extraordinary ability and the NIW, the national interest waiver. On the other hand, the EB-1B for outstanding researchers and professors and the EB-1C for multinational executives and managers, they do require the employer to sponsor them. That means that the employer has to support the process, they have to sign the petition, and otherwise support the process. It is possible for an employer to sponsor an EB-1A or a national interest waiver, but it's not required. Which employment-based category do these classifications fall into? As the name implies, the EB-1 classifications, EB-1A for foreign nationals of extraordinary ability, EB-1B for outstanding researchers and professors, and EB-1C for multinational executives and managers all fall into the EB-1 classification, which is the first preference employment-based classification. On the other hand, the NIW or national interest waiver falls into the EB-2 category. This distinction is important when you're looking at the visa bulletin and determining when a green card may be available for your particular situation. For which of these classifications is a permanent job offer required? That is the EB-1B classification for outstanding researchers and professors. The regulations clearly require that a permanent job offer be in place, whether this is a tenured or tenure track profession or occupation rather position or not, it does require a permanent job offer. On the other hand, the other classifications, for example, EB-1A and NIW, do not require a job offer at all. EB-1C does require a job offer as for you to work, or for the employee rather, to work for the US entity in a position of manager or executive in a certain position. So there is a job offer requirement there. And finally, which positions require experience? That's kind of a trick question. So per the regulations, the EB-1B classification absolutely requires experience. 3 years of experience is required. That is not the case for the other classifications, EB-1A, EB-1C, and NIW. However, because of the nature of the requirements for these particular classifications, you really have to have experience to be qualified. It's not written in the regulations, but more of as a practical matter, you, in general, only a person who has experience, no particular amount of experience required, but a person who has some experience is going to be among those who are potentially qualified. If you don't have any experience at all, then you probably are not going to be qualified. But this is not legal advice. Make sure that you talk with your immigration attorney before you make a decision. So that was a quick overview of these fast track options. Our next video in this series is going to be the first one in a series of videos on the labor certification process, which is a complex process that a lot of people have to go through or get to go through. I hope that you will subscribe to our channel if you find this video or other videos helpful so that you don't miss the next installment. Until next time, my name is Emily Sumner with Sumner Immigration Law.